Welcome, everyone, again to the University of New Mexico Law and Mental Health Series, weekly discussions of practice and science featuring experts in behavioral health and the law. This is a series run by the Division of Forensic Behavioral Sciences of the University of New Mexico's Department of Psychiatry and Behavioral Sciences in support with the New Mexico Behavioral Health Services Division. I'm Anthony Perillo, the Forensic Psychology Training Director here at the University of New Mexico. It's good to be back with everyone here today, and I also want to thank again Dr. Kaisa Marshall for filling in for me for the past month or so. For our talk today, if you have any questions for our presenter, you can ask those anytime you want to through the Q&A box. You can type those questions anytime you feel comfortable. Do know that we hold questions until the end, and oftentimes it's not possible for us to get through all of them. If you are pursuing continuing medical education credits, there will be a sign-in sheet posted in the chat box shortly. If you are pursuing APA continuing education credits, there will also be a link to a survey that you'll complete in the chat box, so keep your eye on that chat box. But that'll be near the end of the presentation, so keep your eye on the chat box near the end of the hour. Make sure that you save, open, otherwise bookmark that link before the webinar closes, so you have the link to complete your survey. And when you complete the survey, make sure that you save the certificate. We don't have the certificates after the fact. If you missed last week's talk in the series, Dr. Georgia Winter's discussion of sexual grooming is now available on our YouTube channel. The recording for this week's talk will also be available on our YouTube channel probably sometime later this week. Those that have registered for the series will also get a PDF version of the slides later this week as well. As a heads up, next week we have UNM's own Dr. Maeve Cardwell discussing vicarious trauma in forensic mental health professionals. But circling back to this week, I'd like to introduce you to today's speaker, who'll be discussing bias in complex forensic decisions. This is Dr. Jeff Kukucka. Dr. Jeff Kukucka is a professor of psychology at Towson University and co-vice chair of the OSAC for Forensic Sciences Human Factors Task Group. His work examines psychological influences, especially cognitive bias, in forensic science and medical legal contexts, including how to detect, expose, and safeguard against unreliable decisions. He's worked as an expert witness in these issues in 15 U.S. states, and he recently oversaw an independent audit of restraint-related death investigations by Maryland's Office of the Chief Medical Examiner. Dr. Kukucka has also won pretty much every award that APLS, the American Psychology Law Society, gives for anybody that's not at the later stages of their career. Early career awards, teaching awards, mentorship awards, dissertation awards, you name it, he's won it. He's a fantastic colleague, and I'll also just say on a personal level, a fantastic friend. So Dr. Kukucka, Jeff, on behalf of the University of New Mexico, thank you so much for joining this series, and we are very excited for you sharing your expertise with us today. I'll go ahead and toss it over to you.
Yeah, thank you, Dr. Perillo. It is my pleasure to be here. You're far too kind and right back at you. Um, the majority of my presentation today will be about that audit that Anthony just mentioned a few minutes ago, but also connecting it to complex forensic decisions more broadly. Before we get into the meat and potatoes of stuff, though, I do have some just orders of business. For those who want to receive continuing education, there will be information on the second slide in the PDF that you will receive very soon. I am disclosing hereby that I have no conflicts of interest, financial relationships, no other commercial interests that need to be disclosed pertaining to this work. And obviously, the stuff that I'm going to discuss today those are my own views, not those necessarily of the University of New Mexico. An important disclaimer. Um, I guess a second disclaimer would be that I am not a clinician. So I gather I am probably in the minority in the room here. But the stuff that I'm going to talk about today pertains to decision making of all kinds, clinical and otherwise. And it's my hope that we'll get three main things out of today's presentation. First, in discussing this audit that we just pulled off in Maryland, I want us to consider the ways in which bias can infiltrate complex forensic decisions, whether that's an autopsy in a death investigation or a clinical assessment or a forensic assessment in a clinical setting, and how bias can indeed lead to erroneous and therefore very costly mistakes. I welcome any questions and critiques of the procedures that we followed in the audit that I'm going to explain to you today. As I'll explain later, this was really a first of its kind endeavor. We didn't have really any sort of blueprint to go off of. So we were very meticulous in how we designed this audit in the hopes that other jurisdictions will follow suit. And finally, and perhaps most importantly, how do we protect ourselves against this scourge of bias when making complex decisions? Or in cases where we maybe can't fully protect ourselves, how can we be as transparent as possible in exactly how we reached the decision that we reached, whether it's an assessment or an investigation or what have you? So, with that, first I will provide some background, what the impetus for this audit was. I'll then walk through the procedure and the findings, talk about the recommendations that we ultimately made to the state of Maryland, and how those same recommendations might also carry implications for complex decision making in clinical psychological settings. As I'm sure we all know, it was back in May 2020, the infamous death of George Floyd, captured on cell phone video while being restrained by a number of Minneapolis police officers. That video obviously went viral and represented somewhat of a watershed moment in a social justice movement and a movement against toward reforming policing practices, I should say. Now, following Mr. Floyd's death, one of the officers, again, you may already be familiar with, Officer Derek Chauvin, was formally charged with Mr. Floyd's murder, and he was actually charged and tried for said murder. And an obvious issue at the trial was how exactly should George Floyd's death have been classified? Was it indeed a homicide? Was it an accident? Was it due to undetermined causes? And at Mr. Chauvin's murder trial, a number of medical experts, medical examiners testified for the prosecution that George Floyd's death was indeed a homicide, that he would not have died if it were not for Mr. Chauvin's actions that day. However, there was one lone medical examiner who testified for Mr. Chauvin's defense. That lone medical examiner is the man you see here, Dr. David Fowler, who served as the chief medical examiner for my home state of Maryland for 17 years. He testified in Mr. Chauvin's defense that Mr. Floyd's death should actually have been classified as undetermined, that its true cause could not be ascertained. It could have been due to a conglomeration of factors, and therefore it was not definitively a homicide. Now, after Dr. Fowler gave this, let's say, controversial testimony in this very high-profile case, it was met with swift and firm resistance from his medical colleagues. What I'm showing you here is an excerpt from a letter, an open letter, that was co-signed by over 450 medical experts across the country, in which they denounced Dr. Fowler's testimony at the Chauvin trial as baseless, as biased, and they called for an immediate investigation into practices at Maryland's Office of the Chief Medical Examiner during the time that Dr. Fowler served as its chief. They were particularly interested in whether there were deaths that should have been classified as homicides, but were not classified as homicides, in the words of the letter, to purposefully usurp a manner of death classification of homicide and therefore accountability for the individuals who may have been responsible for those deaths. So that is where we came in. My colleagues and I, who I'll introduce in just a moment, we were brought on to grant this request and to design and carry out an audit, the goals of which were to determine whether Maryland's Office of the Chief Medical Examiner, or OCME for short, whether OCME was making appropriate manner of death determinations during Dr. Fowler's tenure, or whether there was reason to believe that they were making determinations that were out of step with generally accepted medical practices and national standards for death certification. And inspired by specific concerns that were raised in the letter, we were also asked, to the extent possible, to try to design the audit in such a way that would reveal any evidence of racial or pro-police bias in how Maryland's OCME classified deaths during Dr. Fowler's tenure. Before we go any further, I want to be mindful that we're all coming into this with different levels of familiarity with this topic. So I want to make sure we understand what exactly are the sorts of classifications that medical examiners and coroners are asked to make in the United States. And there are two of them. At the conclusion of a death investigation in the autopsy report, the medical examiner will certify a cause of death as well as a manner of death. And here is the key distinction between those two types of judgments. The cause of death is a purely medical judgment. It is an articulation of the specific injury or disease that led to the person's death. What, physiologically speaking, caused their life to cease. In contrast, manner of death is a more interpretive judgment. Every sudden or unexpected death is classified into one of the five categories that you see on the screen here: natural, accidental, suicide, homicide, or undetermined. This is a peculiarity of the United States. This is not the case in the majority of countries around the world, but in the United States, medical examiners on the death certificate will certify one of these five manners of death, which, as you might imagine, those decisions have considerable implications for what, if anything, happens next. So now that we're familiar with these five manner of death categories, I want to make something very clear, which is that in a medical context, the word homicide means something very different than what it means in a legal context. In a death investigation context, a death that is a homicide is a death that would not have occurred if it were not for the actions of another individual. In other words, another person's actions contributed at least in part to this death. However, ruling a death a homicide does not necessarily imply any criminal liability or wrongdoing on behalf of that individual. So a simple example would be something like a hunting accident. Um, if one hunter, say, fires at an animal and their intent is to hit the animal, but they miss the animal and they actually hit a person who they did not intend to hit, that death, despite the lack of intent, would appropriately be classified as a homicide. However, in a legal sense, that person is unlikely to be held liable for that death. So you can see how manner of death is a much more interpretive decision, right? If a person dies due to a gunshot wound, the cause of death is pretty clear, right? The gunshot wound is what caused their life to end. But then the manner of death becomes more complicated. Was the gunshot accidental? Was the gunshot inflicted by someone else? Was the gunshot an act of suicide? That requires a lot more interpretation and therefore a lot more context. The folks that you see here on the screen are the team that I had the pleasure of working with in designing and carrying out this audit. The bookends on either end are Miss Tiffany Daimo, Ms. Zanita Hurley, two employees of Maryland's Office of the Attorney General, who, in consultation with the Maryland's Governor's Office, were gracious enough to sponsor this audit. The five of us in the middle are the core members of what we call the audit design team. And between the five of us, we represent a range of expertise and experience in not only social science and research methodology, such as myself, but also importantly, forensic medicine. So we wanted to make sure, for obvious reasons, that we involved people with expertise, with medical expertise specifically, in the design and execution of this audit. Now, again, our goal, as stated in that open letter, was to design and carry out this audit, something that no state has ever attempted to do before. So we were kind of blazing new trails here. And our goals were to determine whether the determinations made by OCME for deaths during Dr. Fowler's tenure were appropriate or whether there was evidence of bias or otherwise inappropriate classifications. So the first thing we had to do was make some decisions about, well, exactly which cases are we going to include in this audit? Now, The letter called for an investigation into in custody deaths. Now, for those who may not know, the term in custody deaths is a very, very broad term. It includes not only deaths like Mr. George Floyd's death, for example, but any death while a person is deprived of their liberty is considered an in custody death. So if a person commits suicide while incarcerated, or if a person has a heart attack and dies a natural death while incarcerated, those would also be considered in custody deaths. As a result, as you might have inferred, the majority of in custody deaths tend to not be terribly controversial. So we wanted to really hone in on the deaths that were most controversial, that were most challenging, for which these determinations would have the strongest impact. And what we ultimately decided was we wanted to choose deaths that were as similar as possible to George Floyd's death, the death that distally precipitated this entire audit. So our goal was to identify sudden or unexpected deaths that occurred during or soon after the application of restraint. That could be physical restraint, as we saw in the George Floyd case. It could also be chemical restraint. It could be electrical restraint, right? For example, the use of a taser device. But these are all cases that we're looking for where a person experienced restraint and died either during or soon after that episode. So to start whittling down these cases with the cooperation of Maryland's OCME, who, as you might imagine, now has a new chief in charge, they shared with us a database of over 1,300 in custody deaths, which we then whittled down to 142 cases that showed some indication that restraint may have been a factor. We were then able to obtain the complete, unabridged, unredacted case files for 139 of those deaths. We perused those case files more carefully to determine whether they did in fact meet our inclusion criteria, and we ended up with a final sample of 87 cases. 87 cases. In each case, a person suddenly or unexpectedly died during or soon after being restrained, in some cases by police officers, in some cases by other individuals, which we'll circle back to in just a moment. Of these 87 individuals, these 87 cases, these 87 deaths, the overwhelming majority of the decedents were men. 84 of the 87 were men. Nearly three-quarters of these individuals were people of color, including 61 Black and 2 Hispanic individuals. The other 24 decedents were white. And as I just mentioned, most but not all of these individuals had been restrained by police officers. So just over three-quarters of them were restrained by police. The other 19 cases, they were restrained by non-police individuals. That may be bystanders, security guards, emergency medical personnel, firefighters, neighbors, friends, family, and so forth. Anyone who was not a sworn police officer. Okay, so we have these 87 case files. Now, our ultimate goal, as I'll explain in just a moment, was to recruit an independent panel of medical experts to review these case files and gauge the extent to which their opinions about these cases were consistent with OCME's opinions about these same cases. But before we could do that, we had to do some cultivating of these case files, mostly for reasons of privacy and confidentiality. So for each of these case files, the first thing we did is any documents that were purely administrative in nature, things that are completely irrelevant to a medical determination of manner of death, we removed those documents entirely. We're talking about things like documents pertaining to funeral arrangements, cover sheets from fax machines, things that are unquestionably irrelevant to a medical decision. Every other piece of paper that was in that case file was given to our independent reviewers so that we couldn't be accused of not providing a comprehensive account of what was known about this case. Secondly, for obvious reasons, we redacted any personally identifiable information about the individuals involved in these cases. The names of the decedents, the names of the decedents' families, their addresses, phone numbers, social security numbers, VIN numbers, driver's license numbers, anything that could be considered remotely sensitive, we digitally redacted. We did the same actually for the OCME personnel who worked on the case as well. Whether they were OCME employees per se or consultants, any medical professional who worked on the case in a death investigation capacity, their identity was redacted. Again, because it's a relatively small community, we wanted to make sure that our independent reviewers didn't know who handled these cases originally. The next thing we did, and this is important, we wanted, to the extent possible, for our reviewers to evaluate these case files without knowing the race of the individual who had died. So to that end, we did two things. The first thing we did is any mention of the person's race, we digitally redacted. So you can see one in the first sentence here under external examination. It says the body was that of a well-developed, well-nourished, unclad blank male. I do not know what word is hidden behind that redaction. That is precisely the point. We also redacted any information that might be used to infer the person's race, namely their eye color, their hair color, and their hair style. But there was a problem. Even after redacting all of that information, we still had, for nearly all of the cases, photographs of the decedent, photographs of the autopsy, photographs of their body that necessarily gave away what the tone of their skin was. So to get around that issue, and I'll come back to this much later in today's presentation, we employed a procedure called linear sequential unmasking. In this context, what that meant is we took each case file and we split it into two pieces. One file contained all of the photographs of the decedent, anything that necessarily gave away the tone of their skin color. Everything else went in a separate file. And as I'll explain in a moment, what we had our reviewers do was first review the entire case file except for the photos, and to render an initial judgment or initial set of judgments based solely on that information. Then and only then, once they had locked in that initial judgment, did we allow them to see the autopsy photographs and, if they so desired, to revise the judgment that they had made previously. That way, their first round of judgments was made without knowledge of the decedent's race, but their ultimate judgment utilized all available information, including the autopsy photographs. The last thing we redacted, again, a pretty obvious one, we didn't want them to know what OCME's original determinations of cause and manner of death was. We wanted them to form their own independent opinions. So we redacted OCME's judgments, which, as I'll explain in a second, we later unredacted and we asked the reviewers to comment on. Speaking of our reviewers, we cast a very wide net. Through 15 different professional organizations of death investigators and other relevant medical experts, we sent solicitations for volunteers to participate as case reviewers for this audit. We ultimately received about 36 some odd applications. We carefully vetted all of these individuals for both their qualifications and any real or perceived conflicts of interest, negative media coverage, and so forth. We wanted people who were unquestionably eminently qualified and as squeaky clean as possible in terms of having no controversy, no conflicts of interest related to their work. So we ultimately ended up with a panel of 12 reviewers, 7 women and 5 men, who served as our case reviewers for the purposes of this audit. 7 of them were based in the United States. The other 5, as you can see here, were based in other countries, including 3 from the UK, 1 from Canada, and 1 from South Africa. With respect to the race of the case reviewers, exactly half of them identified as people of color, as you can see broken down here. The other half self-identified as white. And most importantly, these were highly qualified, highly experienced medical professionals. They were all board certified forensic pathologists who were actively practicing in the field and had an average of 14.2 years of experience in practice, with a minimum of 6 years of experience and a maximum of, I think it was 29 years of experience. So these were the individuals who we chose to entrust as outside, independent, unaffiliated experts to review these case files so that we could eventually compare their opinions against OCME's determinations and see to what extent the two are in agreement with each other. Okay, this is arguably the most important slide because this is where I'll run us through the procedure from start to finish. There were 87 total cases, as we previously discussed. Every week for 11 weeks, I selected a random 8 of those 87 cases. And each of those cases was distributed to 3 of the 12 reviewers in a quasi-random fashion. The only thing that made it quasi-random was that we made sure each reviewer got exactly 2 cases per week, and we made sure that each case was assigned to at least one US-based and at least one international reviewer. Those 3 reviewers were directed to a secure website where they could access the entire case file digitally, at this point, minus the photographs. So each of those reviewers independently reviewed the case file and completed a survey in which they not only provided their opinions about the quality of OCME's work, but they also locked in opinions about cause and manner of death for that particular case. After those opinions were locked in, as I mentioned earlier, we now unmasked, we revealed the autopsy photographs, and we gave the reviewers an opportunity to revise their previous opinions if they so chose. As it turns out, it was very rare that reviewers changed their opinions after seeing the photographs. It only happened about 3% of the time. When it did happen, as you might imagine, we asked them to justify why they had changed their opinion. And in every case, they said that there was information in the autopsy photos that wasn't documented in the report, things like injuries, obesity, and so forth, that they weren't aware of and that caused their opinion to change. Now, at this point, the case file has been reviewed by 3 independent experts, each of whom has locked in separately an opinion about the manner of death. What we then did is we compared those opinions against each other. Were these reviewers unanimous, or was there disagreement over the manner of death in this case? If they were not unanimous, what we did is we convened a virtual meeting manner of death if possible, but we also made abundantly clear that they were not at all required to reach a unanimous opinion if that proved not to be possible. Obviously, if the 3 reviewers each independently reach the same opinion, that consensus means separate survey to each of the independent reviewers again. We revealed what OCME's determinations for this case were, and we gave them the opportunity to comment on those determinations now that they had locked in their own opinions. Okay, getting into the results. The table that you see on the screen right now will populate with numbers in just a moment, but before it does, I want to make sure we're all clear on how the table is laid out. The primary goal of the audit was to assess the agreement between reviewers' evaluations of these same cases compared to OCME's original determination for those cases. So for these 87 audit cases, what we have here in the rows is OCME's original determination, homicide, accident, natural, and undetermined, respectively. Across the columns from left to right, we have the consensus opinion of our case reviewers. Again, homicide, accident, natural, undetermined, and then as you'll see in a moment, some cases where the reviewers did not achieve consensus. So here are those numbers. Let me walk you through what I see as the most important takeaways here. First, there were 13 cases, about 15% of the cases, for which the 3 reviewers assigned to that case, despite discussing the case with each other, could still not agree about what the manner of death was, which would suggest that these were particularly difficult, particularly complex cases, maybe cases where the available documentation was particularly lacking, and for that reason, they could not reach consensus. Perhaps not surprisingly, for 11 of those same cases, OCME also certified the manner of death as undetermined, which again suggests those cases were just highly, highly difficult, highly ambiguous. The bolded numbers along the diagonal represent cases where the consensus opinion of our reviewers was the same as OCME's original determination. Or, in other words, our reviewers effectively agreed with OCME's opinion. That happened for just over 1/3 of the total cases in the audit. Now, I'll remind you that in the letter that precipitated this audit, one of the key concerns expressed by those medical professionals was that there may have been an undercounting of homicides at OCMA during this time frame. Now, as it turns out, of the 87 cases that were included in the audit, OCME did certify 12 of those cases as homicides. Our reviewers, who reviewed the same 87 cases, believed that 48 of those cases should have been classified as homicides. So if we take the difference between those two numbers, 48 minus 12, leaves us with 36 cases that OCME believed were not homicides, but that our reviewers independently evaluated and unanimously agreed should have been classified as homicides. These are the cases that are of particular concern because it suggests an undercounting of homicides following restraint in Maryland during this time frame. We'll come back to that a bit later. We were also asked to look for any potential evidence of racial or pro-police bias in OCME's determinations. Now, given the retrospective nature of this audit, right? It's not an experiment. We can't randomize things. We can't control for things. So we are somewhat limited, as I'll explain in a minute, we are somewhat limited in terms of our ability to draw definitive conclusions about bias. But here's how we chose to go about addressing this question. The data from the previous slides suggest that, as evidenced by those 36 seemingly misclassified cases, OCME was undercounting homicides during this time frame. So the question we then asked was a homicide more likely to be undercounted if it was, say, the homicide of a death of a black individual, or if it was the death of a person who was restrained by police as opposed to by other persons? So what we did, excuse me, what we did is we focused specifically on the 48 cases that our reviewers unanimously believed should have been classified as homicides. And we then looked to see what percentage of those cases actually were certified as homicides by OCME. So if we look at just those 48 cases, there were 16 cases that involved the death of a white individual, and there were 32 cases that involved the death of a black individual. Now, again, every single case that you're seeing on the screen here is one that our reviewers unanimously believed should have been classified as a homicide. But when we go back and look, OCME classified 44% of the white deaths as homicides, but only 16% of the black deaths as homicides, which is consistent with the question we were trying to answer, right? That homicides were undercounted in general, but it appears that they were undercounted even more dramatically in cases where the decedent was black. We took a similar approach to looking at the possibility of pro-police bias. Of those 48 consensus homicide judgments, 13 cases involved restraint by non-police. The other 35 involved restraint by police. Again, these are all cases that our reviewers thought should have been certified as homicides. For the non-police restraint, 54% of them were. For the police restraint, only 14% of them were. So same sort of pattern here, right? It suggests that there was an undercounting of homicides in general, but that undercounting was even more dramatic if there were police involved in applying the restraint. Now, again, it's important to note that we did not have control over this in the experimental sense. We did not randomize anything. We could not standardize anything. It is therefore possible that these subsets of cases, whether we're talking about police versus non-police or white versus black decedents, it is possible that those cases systematically differ in ways other than the ways that we have identified. So there may be competing explanations for these differences, right? Now, it's also worth reiterating that our reviewers' judgments were made without knowledge of the decedent's race, and they very rarely changed their judgments after learning of the decedent's skin tone. We, however, could not reasonably mask who was applying restraint in these cases. So our case reviewers were aware of whether the restraint was applied by police or by other individuals. Because given that limitation, we wanted to take a closer look to see if there was any other indication of pro-police bias in these determinations. And here's what we did. We went back and we did essentially a content analysis of OCME's official cause of death statements. What did the autopsy report actually list as the person's cause of death? And importantly, did it mention that restraint may have played a role in the death? Now, for the 19 cases where individuals died after being restrained by non-police, about 3/4 of the time, OCME's official cause of death statement acknowledged that restraint may have played a role in this death. However, for the 68 cases where police applied restraint, only in about half police bias, but not definitive evidence of it. Lastly, we've talked exclusively so far about manner of death. I want to talk very briefly about cause of death, particularly a cause of death called excited delirium. Excited delirium is a theory that's been around since the mid-1980s, and it has been used to explain deaths in police custody, deaths involving restraint, as resulting from an unusual state of physiological agitation. It has been heavily criticized as being used to absolve police of accountability. It has been criticized as being applied in a racist, inequitable way. And it has, in recent years, been thoroughly discredited as a non-valid cause of death. This is not a real medical condition. It has since been rejected by every major medical organization, including, as you can see here, the American Medical Association, as well as several others, including the National Association of Medical Examiners, the largest professional organization of death investigators. So with that as a backdrop, we wanted to get a sense of the extent to which Maryland OCME's death investigations were relying on this now discredited diagnosis during the audit's time frame. As it turns out, they relied on it quite a bit. In nearly half of the cases in the audit, 42 of the 87 cases, OCME's cause of death statement mentioned excited delirium or some variant of that now discredited term. And perhaps not surprisingly, whenever OCME attributed a death to excited delirium, they almost invariably certified that death as undetermined. Now, out of curiosity, we looked back at those same 42 cases, the cases that OCME had attributed to excited delirium, and we wanted to know how exactly our case reviewers opined about those cases. 60% of the time, they judged those cases as homicides. So the takeaway message here is that OCME's reliance on this now discredited, outdated, invalidated concept of excited delirium was a key factor behind their undercounting of homicides and behind their misclassification of deaths. However, it was not the sole factor. There were other factors at play here because, of course, there were other deaths that were not attributed to this condition but were misclassified nonetheless. So to quickly summarize the key findings of the audit, first, overall, if you compare our reviewers' judgments against OCME's determinations for those same cases, there is a strong, strong suggestion here that OCME systematically undercounted homicides during the audit's time frame, which is, again, substantiating the concerns that were raised in that open letter that you saw earlier. Our analyses vis-a-vis bias suggested that the undercounting of homicides was even stronger in cases where the decedent was Black and or was restrained by police, which again are patterns that are consistent with the possibility of bias, but are not definitive proof of bias because the nature of the audit doesn't allow us to draw such a conclusion. With respect to cause of death, OCME made frequent use of the now discredited concept of excited delirium, and they almost invariably certified those deaths as undetermined. But when our reviewers looked at those same deaths, they judged 60% of them as homicides. Now, in a moment, I'm going to show you a link to the full report. Obviously, there's a lot more detail, there's a lot more nuance than this. Our report concludes with a few sets of recommendations. There's a set of recommendations for police, there's a set of recommendations for the Attorney General himself. And the ones I'm going to quickly share with you now are the recommendations that we made for OCME. And the reason I'm focusing on this is that these individuals are the folks who are doing the hard work and making the hard decisions, much like yourselves, right? Not unlike a forensic clinical assessment, these individuals have to receive and integrate and interpret information from different sources, some of which is self-generated, some of which is other generated, and they also ultimately have to make a very complicated decision. So the recommendations that I'm about to put on the screen are recommendations that stem from not only the data, but also from qualitative comments that were provided by our case reviewers when we asked them to reflect on how OCME's practices could be improved. And as I'll explain on the next slide, I think there are a lot of parallels here between how to improve decision making in death investigation contexts and how to maximize the quality of decision making in the context in which you all work. Now, the first two recommendations that we make are frankly low-hanging fruit. We're telling OCME you need to get in line with the most current science in the field. You need to get in line with national standards, with generally accepted practices for death investigation in two ways. First, excited delirium has been discredited. It's been rejected by major medical organizations. You need to reject it as well. You need to stop using it. And I'm pleased to say that as of a few years ago, even before we released this report, OCME, under its new leadership, had already proactively taken this step, that they no longer rely on this discredited diagnosis in their cause of death formulations. The other one pertains to adhering more closely to the official standard for what constitutes a homicide. As I mentioned earlier, the medical definition of homicide simply means this person would not have died were it not for the actions of that person. But it does not necessarily mean that that person is at fault, that they are criminally liable, that there was any wrongdoing at play. But if, in fact, a human's volitional act is contributing to a death, that is important information to have from a public health perspective. Because the core purpose of the death investigation system is to identify and therefore prevent deaths that could potentially be avoided, right? So by undercounting, by neglecting to acknowledge the human contribution to these deaths, we're missing out on opportunities to make the public safer, right? And to potentially prevent similar deaths in the future. Other recommendations of ours were more specific and more procedural. First, transparency, transparency, transparency. More photos of the decedent, higher quality photos of the decedent, more documentation of the information that actually informed the decision that was ultimately made. I mentioned this already, but I'll reiterate, continuing education, right? You all are ahead of the curve just by being here, but by staying up to date on the most current science allows you to make the most reliable decisions. Our reviewers noted some concerning variability in how OCME handled different cases. And they said there needs to be more standardization here, right? As we all know, standardization tends to serve as a prophylactic against bias. It's not a cure, but it tends to move the needle in the right direction. So to the extent that OCME can not only develop better procedures, but also standardize those procedures across cases, it serves to alleviate that concern a bit. And finally, expanded quality control measures. Things like, for example, periodic external peer reviews of OCME's work to make sure that they don't get siloed, right? To make sure that they're still meeting some minimum standard of quality with respect to the field writ large. As promised, here is a link to the full report, which came out back in May. It is long, it is dense. There are many tables, many appendices. But if you are, the sort of person who wants to dig into it a little deeper, I very much encourage you to do that. So for you all, right, you are not death investigators, you are not coroners, medical examiners, and so forth. But in the course of your work, you make challenging decisions all the time that require you to integrate large amounts of information that may vary in terms of its reliability, that may vary in terms of its relevance to the decision. So, what are some bigger picture takeaway messages, some lessons that we can learn from this audit that apply to complex decisions in forensic settings in general? First, again, you're already doing this. But staying up to date on the newest and the strongest scientific knowledge in your field will enable you to make the best possible, the most informed possible decisions. That's a no-brainer. Second, the standards that you follow to make these decisions, to the extent possible, need to be articulated clearly, need to be standardized, and need to be objective. To the degree that we can promote consistency and clarity, there is less room for bias to infiltrate and undermine our decisions. This is an important one. We want to make sure that our decisions are based on the best possible information. Notice I didn't say the most possible information, but the best possible information. We want the information that informs our decisions to be reliable and to be objective. In the context of death investigations, that might take the form of something like a police body-worn camera that actually shows for how long the person was restrained and in what position they were restrained and what their behaviors were while they were being restrained. So that we don't have to rely on secondhand accounts. We don't have to rely on the fallibilities of human memory. We actually have an objective record of what happened that can be transmitted to the death investigator to get that information. There are obvious analogs with respect to clinical assessment as well, right? We want the information that informs your decisions. We don't want you to sort of consider everything indiscriminately. We want you to focus on the information that is most objective, most trustworthy. Transparency is a big one. I'm a big, big proponent of transparency. A decision is useless if we don't know where it came from. And as somebody who testifies in court a lot, one of the things I find myself saying the most is, yeah, they told me what their decision was, but I have no idea how they reached that decision, and therefore I have no idea whether the decision is any good or not. So documenting not only the punchline, but how you got there, right? How did your decision evolve? What informed your decision? On the next slide, I'm going to briefly talk about a protocol that we've developed to promote that sort of transparency in complicated decision settings. And finally, with respect to death investigations, we called for expanded quality control, maybe external reviews. Ideally, those reviews would be periodic. Ideally, they would be masked to race or other potentially biasing factors. A form of ongoing peer review to make sure that the standard of quality is being met. Could certainly imagine something similar in a clinical assessment context, right? Where periodically there are peer reviews that go on to make sure that standards are being followed. So how specifically can we protect ourselves against bias in decision making? Again, as somebody who works a lot of these cases, albeit in the context of crime labs and medical examiners' offices, what I see all too often is people get the information that they get in whatever order they happen to get it. There's really no thought, there's no strategy, there's no structure that goes into it. It's, well, I got this piece of information first, and I got this piece of information second, and I didn't really need this piece of information, but I got that one third. It's very haphazard, it's very unstructured. What we have done in recent years is we have developed and promoted a procedure that we call linear sequential unmasking expanded, or LSUE for short. And it's very simple. All we're advocating for is instead of doing this in sort of an aimless way and considering information indiscriminately and in whatever order you happen to get it, we're saying make advanced decisions, strategic decisions about what information you're going to consider and in what order you're going to consider it. So if there's a piece of information that's irrelevant to your decision, don't look at it. Don't use it. It can't benefit you. It can only undermine the trustworthiness of your decision. With respect to information that is relevant, there are gradations of relevance, right? This also allows for the possibility that some information may be relevant, but also potentially biasing, like we saw with the autopsy photographs in the audit. So the solution isn't to mask that information entirely. The solution is to delay it, right? Start with the information that is most relevant, most objective, least biasing, and then and only then progress to considering other information that's maybe relevant but less so, or maybe biasing but more so. And all the while documenting carefully how exactly your decision evolved over time, or how your confidence in that decision evolved over time. And we have actually published some tools to make it easier for decision makers to do this, where they can actually document, here is the information I considered, here is the order in which I considered it, here is how my decision evolved over time as a result, and here are any safeguards that I might have taken to protect myself against the possibility of bias. So there's an element of transparency here, but there's also an element of protection, right? That you're actually putting in writing, these are the steps that I took to make sure that my decision was as trustworthy as possible. Anthony and/or Alex, feel free to jump in here. I'm assuming this is the same Qualtrics link for the folks who want to fill that out. Um, we have a couple minutes left for questions, which I would be more than happy to take. And I'll turn it back over to you to tell me what to do next.
Yeah. Well, thanks. Yeah, thanks so much, Jeff, for, one, all of the work that you put into this with Maryland, and then sharing all of this information and recently released information here with the audience. As you did reference here in the chat box now, Alex has put in the direct hyperlink for the survey for those that want APA continuing education credits. You can also scan the QR code that Jeff has posted up here. We do have a couple of questions that are in the Q&A box right now. In the meantime, if you have any other questions about the presentation or for Dr. Kukucka otherwise, you can enter those in the Q&A box anytime you feel comfortable here. Someone, in terms of asking about the reviewers themselves, inquired about if any of the independent reviewers were also signers of that original OCME letter of concern, and any thoughts.
Excellent question. And the answer is there was one reviewer who was a signatory of the letter. Um, the other 11 were not. Uh, when we sent the solicitation for individuals to volunteer to be reviewers, we had them fill out a very thorough application, in which they had to disclose not only their professional experience, but also any previous relationships with OCME, any previous relationships with said letter. We also, frankly, Googled them. We wanted to make sure that these were people who were not going to be controversial, people who were well respected in their community, and I'm very satisfied with that. We actually interviewed. Gosh, I don't remember how many exactly we interviewed, but we of the folks that we interviewed, we actually extended offers to fewer than half because we wanted to have a really, really high bar, in terms of credentials and integrity to participate.
Was there any examination or consideration of potential bias of the reviewers themselves and how that was factored into the analysis? Something jumps out. Were there any, every once in a while when there was a disagreement, did we see reviewers that were disagreeing in a particular way that suggested a possible bias?
That's a great question. Anecdotally, I can tell you that the individual reviewers certainly differed in terms of their proclivity toward or against different decisions. On a broader level, I would say, like I mentioned earlier, we could not realistically blind um, our reviewers to who applied restraint, right? If a taser was used, it probably was not used by a civilian. If handcuffs were used, they probably were not used by a civilian. And that's medically relevant information that we can't redact, right? So that is one of the things we discussed at some length in our report is, um, it is certainly possible that the findings that I just shared are consistent with pro-police bias at OCME. It's also possible that they're consistent with anti-police bias among our reviewers, or some combination of those two things. And again, unfortunately, the retroactive design of the audit prevents us from knowing that, right? The way I've been explaining it to people is if I go outside and my lawn is wet, it's possible that it rained, but there are also other reasons why my lawn could be wet, right? So I can't prove that it rained, but what I can say that is if it did rain, this is what the result would look like. We have a similar thing going on here.
Someone noted that when you do redact the files, that the reviewers then weren't actually reviewing the same information OCME had. Their question is that a source of bias in the study that would make reviewers more likely to reach a different conclusion than
Hmm.
OCME? And that by excluding two-thirds of reviewers, would that increase the chances that these reviewers would not match OCME? OCME. Any thoughts on that?
With respect to the second question, there's really no way to know. It's a the core issue there is sort of volunteer bias, and we never know when we're doing research how the people who chose not to participate differed from the people who did. What we can say is that, as I mentioned earlier, our priorities were qualifications and integrity and zero controversy surrounding these individuals. So we didn't want people who we knew were critics of OCME. We also didn't want people who we knew were critics of the audit. We wanted people who we believed could be impartial. Um, with respect to the redactions, I think that's why it was so important that we involved um, medical professionals, medical experts, forensic medical experts specifically, in the redaction process, because we needed to be sure that we weren't redacting any information that was actually useful in making these determinations, right? Something like, hair color a manner of death determination should not hinge on a person's hair color. So we can safely say that information can be redacted to mask a person's race without impeding their ability to make an informed decision. But there were, in some cases, very contentious conversations among the committee about what we should and shouldn't redact. We ultimately chose to take the most liberal approach possible by redacting as little information as possible because we didn't want to be criticized. We didn't want there to be any room for a perception that we were somehow putting our thumb on the scale by choosing what the reviewers were or weren't allowed to see. We redacted as little as humanly possible, and we are relying on, and we have no reason to doubt that OCME gave us everything they had for any given case.
Thank you so much for that. And then transitioning into broader questions into the recommendations, less so than the audit. If you could clarify how deciding in advance information that you would consider would not incur confirmation bias.
That is a tough question, right? Because reasonable people may have disagreements about the degree to which, or indeed whether something is relevant at all. And I think those of us who are researchers, I think, face a similar quandary where there are many different ways you could answer a given research question. And at the end of the day, and I know, if anyone else in here who's a teacher, I know my students struggle with this. I imagine yours might as well. There isn't always an obvious agreed upon right answer. The right answer is of how people go about making their decisions. The important bit is that we know how they chose to go about making their decisions and that that information is documented and that it's justifiable, and that it could be reviewed by another party.
Get it, you kind of springboarding into some of those practical considerations. A colleague here, I think these are conversations that you and I have had here, Jeff, and in my more forensic assessment field, where Julie Gallagher is noting individuals in solo practice often
Mhm.
struggle to implement linear sequential unmasking expanded because
Mhm.
sometimes it's hard to avoid that initial exposure to the file, or sometimes we have practical limitations. We have to wait for a file if we're ever going to get medical records. We can't depend on a
Yep.
certain order. Do you have any advice for these situations where it's just hard to avoid certain information? Or as sometimes I've told you, like sometimes a file is described or a file is so vague and can could have so many different types of information, you don't
Yep.
know if it's relevant or biasing until you actually see it.
That's a great question. And I wish I had a more sophisticated answer for this because you're right. How can you know whether something is relevant without looking at it first? And then once you've looked at it, if you find that it is biasing, well, now you've seen it and you can't unsee it. So that is a very sticky question that I don't have a great answer for. Um, I can tell you that there is an analogous problem in many crime labs that are understaffed and or underfunded, where, in a circumstance like that, an obvious recommendation might be, well, if you feel that this examiner was exposed to something potentially biasing, reassign the case to a different examiner. And they come back and say, we only have one examiner, right? What do you want us to do? Um, so, some other ways around that have been, and this is, as you might imagine, as somebody who testifies about bias a lot, I have to be very careful to practice what I preach so as not to be called a hypocrite in court. Being very selective about what information you solicit. Um, in some cases, particularly complex cases, maybe relying on a colleague who's willing to act as a filter of sorts. In the crime lab context, we would call that a case manager, a person who acts as an intermediary between the submitting agency and the person who's actually doing the analysis. And in so doing, they have the expertise to filter out any information that is irrelevant. But I still don't think it satisfactorily addresses that question because there are really legitimate practical constraints that can make this really challenging, which is why I think transparency is really important. And I also think it's why, demystifying the word bias is really important. And making clear that bias is not malfeasance, it's not misconduct, it's not laziness or incompetence. It's a part of how our brain processes information. And by being transparent about the fact that we all, myself included, are vulnerable to this phenomenon, doesn't make us bad people or bad professionals.
Jeff, Dr. Kukucka, thank you so much for the work you're doing here. What a study, what a story, all that, and the work that you've done and sharing all of that for us. A number of people here thanking you so much for this. Someone adding that it did hurt their spirit to hear these results. That's the information that we have here. But thank you so much again for sharing all of this, the work you do here. Dr. Kukucka has a number of different publications and works related to cognitive bias and forensic decisions that you could see more information about this further. And that does wrap up this week's Law and Mental Health series. We hope to see you next week when Dr. Maeve Carwell will be discussing vicarious trauma in forensic mental health professionals. We hope to see you then for another great discussion of issues in behavioral health and the law. And until next time, take care.